Good day everyone. So for this session, we will be discussing about the levels of proficiency by Patricia Benner and the Code of Ethics and ethical and legal responsibilities. So at the end of this lesson, you should be able to explain the roles and responsibilities of the health profession considering the respective code of ethics of the different health profession, understand the roles and responsibilities of individual members as part of the healthcare team, including their ability to promote the delivery of quality healthcare, identify the professional, legal, and moral responsibilities and their accountabilities, identify the implications of each action if done outside of the scopes and responsibilities, and follow through codes and procedure in carrying out moral responsibility towards others. So the levels of proficiency posits that in the acquisition of development of a skill, a student passes through 5 levels of proficiency, which is novice, advanced beginner, competent, proficient, and expert. So these different levels reflect changes in 3 general aspects of skill performance. First, one is a movement from reliance on abstract principles to the use of past concrete experience as paradigms. So when we say past concrete experiences as paradigms, it means like the quote, I hear and I forgot, I see and I remember, I do and I understand by Confucius. In this first stage of the cycle, a person has an experience that serves as the basis for observation. The individual encounters a new experience that creates an opportunity for learning. So, a person cannot learn by simply observing or reading. So, the goal is for the individual to actively participate in the experience so they can learn from it. Second, is a change in the learner's perception of the demand situation, in which the situation is seen less and less as a compilation of equally relevant bits and more as a complete whole in which only certain parts are relevant. So learner's perception of the demand situation means learning is the acquisition of habits, knowledge, and attitudes. It involves a new ways of doing things, and it operates on additional attempts to overcome obstacles or to adjust to new situation. It also represents progressive change in behavior and enables to satisfy interest to attain a goal. So these strategies we usually use by doing what feels good and right and how we learn best. So there's no right way to learn in a specific situation. So everyone has his own style on learning, which can also vary from one situation to another. Then the third is a passage from detached observation to involved performer. The performer no longer stands outside the situation but is now engaged in the situation. So engaged in the situation means patient engagement in healthcare. So being as informed as possible about their options for treatment, medication, recur, recuperation, and all other aspects of healthcare system supporting them. So patients engagement involves providers and patient working together to improve health. So let's start with the stage one, which is a novice. So it is they are beginners, have had no experience of the situation in which they are expected to perform, and novice are taught rules to help them perform. So the rules are context free and independent of specific cases, hence the rules tend to be applied universally. So the rule governed behavior typically of the novice is extremely limited and inflexible. So as such, novices have no life experience in the application of rules. So in the stage one, so they are task or skilled focus. So example, they will just going to fill the IV bottles. You're going to pass the medications. Then, as what stated in here, they are a rule follower. Those who they follow instructions. So just tell me what I need to do and I'll do it, something like that. Then they are also inflexible. So when we say inflexible, wants to be told what to do in order to do tasks. So they're going just to ask what needs to be done, and then they're going to do. Then the second stage, so advanced beginner are those who can demonstrate marginally acceptable performance, those who have coped with enough real situations. So let me take note of this one, who have coped with real situations, to note or to have pointed out them by a mentor. So they still needs a mentor. So the recurring meaningful situation component. So these components require prior experience in the actual situation for recognition. So principles to guide actions begin to be formulated, and these principles are based on experience. So in stage 2 advanced beginner, they still requires mentor, as what I've mentioned, or experience to assist with defining situation, to set priorities, and to integrate practical knowledge. Third is competent. So competence is typified by the provider who has been on the job in the same or similar situations 2 to 3 years, and they develop already when the provider begins to see his or her actions in terms of long-range goals or plans of which he or she is consciously aware. Then for the competent provider, a plan establishes a perspective plan based on considerable conscious, abstract, analytic contemplation of the problem. And the competent stage is the most pivotal in clinical learning because the learner must begin to recognize patterns and determine which elements of the situation warrant attention and which can be ignored. So the conscious, deliberate planning that is characteristics of this skill level helps achieve efficiency and organization. So the competent provider lacks the speed and flexible of the proficient nurse or provider or medtech or pharmacist or whatever health practitioner, but does not or does have a feeling of mastery and ability to cope with and manage the many contingencies of clinical setting. So the competent person does not yet have enough experience to recognize a situation in terms of an overall picture or in terms of which aspect are most salient or most important. So in the stage 3 competence, so they are already a good time management. So they schedule their day, they plan and think analytically. Then stage 4 proficient. So after 3 to 5 years, at this level, demonstrate a new ability to see changing relevance in the situation, including the recognition and the implementation of skilled responses to the situation as is evolves. So the proficient performer perceives situation as wholes. So rather than in terms of chopped up parts or aspects. And performance is guided by maxims. Proficient provider understand a situation as a whole because they perceive its meaning in terms of long-term goals. The proficient provider learns from experience and typical events to expect in a given situation, and plans need to be modified in response to these events. So at this stage, the provider can now recognize when the expected normal picture does not materialize. So this holistic understanding improves the proficient provider's decision making and becomes less labored because the provider now has a perspective on which of the many existing attributes and aspects in the present situation are the important ones. So basically, they are holistic understanding for stage 4 proficient. Then for the stage 5, the expert. So the expert performer no longer relies on analytic principle such as the rules, the guideline, the maxim to connect her or his understanding of the situation to an appropriate action, and the expert operates from a deep understanding of the total situation. So what does this mean? So the expert performer no longer relies on analytic principle to connect her or his understanding of the situation to an appropriate action. So the expert provider with an enormous background of experience now has an intuitive grasp of each situation and zeroes in on the accurate region of the problem without wasteful consideration of a large range of unfruitful alternative diagnosis and solutions. So the expert operates from a deep understanding of the total situation, so such as the chess master. So for instance, so when asked why he or she made a particular masterful move, we'll just say because it felt right, it looked good. So the performer is no longer aware of the features and rules. His or her performance becomes a fluid and flexible and highly proficient. So this is not to say that the expert never uses analytic tools. Highly skilled analytic ability is necessary for those situations with which the provider has had no previous experience. So analytic tools are also necessary for those times when the expert gets a wrong grasp of the situation and then finds that events and behavior are not occurring as expected. So when alternative perspectives are not available to the clinician, the only way out of a wrong grasp of the problem is by using analytic problem solving. So that's for the stage 5 or the expert. So for the stage 1, so novice, it has no professional experience. The beginner can note recurrent meaningful situation, components, but not prioritize between them. For the competent, begins to understand actions in terms of long-range goals. Then proficient perceives situations as wholes rather than in terms of aspect. And the 5th stage, expert, has intuitive grasp of the situation and zeroes in on the accurate region of the problem. So for example, code blue. I believe you've heard this one already in movies or in K-drama or telenovela, wherein it is an emergency situation announced in a hospital or institution in which a patient is in cardiopulmonary arrest, requiring a team of providers to rush to the specific location and begin immediate resuscitation efforts. So for stage 1, the novice, here, the person or the provider is very nervous or how he or she can get help. So getting help is in the situations because they have no background at all or experience at all. Then for the stage 2 advanced beginner, since they have already experience, so they will start already CPR or cardiopulmonary resuscitation because as what I've mentioned, they might have experience already or they already encountered a code blue scenario. Then for the 3rd stage, competent, so the provider do here will be he or she will thinks if he or she needs the crash cart or the emergency cart containing the medicines needed and materials, or do he or she starts recording what is going on. So that's for the competent stage. For the stage 4, proficient, so thinking the next step, example is the nurse starting the CPR. He or she will think to do or provide IV medications already. He or she will start the IV medications or thinks to call the pharmacist, calls the doctor. So thinking further in advance what is going to happen. Then of course for the 5th stage is the expert. So they are the one who is in charge, one who runs the codes, or ones who going to instruct, like he or she will instruct to get the card, call the doctor, or call the family member that is that kind of stuff. So another one that I want to point out is that you are a provider of a certain area for so long, you cannot be immediately be expert. For example, if you're going to be transferred from a different area, so since you are not expert in that new area, so you will become a novice again, because you need to learn again the basic knowledge or informations in that new area. All right, so next is professional standards. So when we say professional standards, so these are sets of practices, ethics, and behaviors that members of a particular professional group must adhere to. So these are sets of standards frequently agreed to by governing body that represents the interest of the group. So they reflect a desired and achievable level of performance against which a provider actual performance can be compared. So the main purpose of the professional standard is to direct and maintain safe and clinical competent in the clinical practice. So we have here some of the professional standards. So first is accountability. So takes responsibility for their actions. So you are accountable. So whatever happens to that patient, you are liable to that patient. Whatever actions you will do, you are liable to what will happen to the patient. Then confidentiality keeps all sensitive information private and away from those who shouldn't have access to it. So, as a health provider, we should not tell any sensitive informations who are not involved in taking care of a certain patient. Then, fiduciary duty places the needs of clients before their own. It's somehow synonymous with confidentiality, which includes a duty not to disclose any medical information received in connection with the treatment. Next is honesty, so always being truthful. So for example, if you're going to assess the patient, whatever we see, we feel, we touch or smell during the assessment, we need to document honestly and correctly. Then integrity, having strong moral principles. Of course, we should do good by not harming the patient. Then law abiding, so follows all governing laws in the jurisdictions they perform activities. So here in law abiding, so we should follow whatever the protocols in a certain institution. Then loyalty, so remains committed to their profession. So if you are that professional in the future, you should be loyal in serving the people by taking care of those who are in need. Then objectivity, so not swayed or influenced by bias. So when we say bias, for example, you need to treat them equally. Then transparency, so revealing all relevant information and not concealing anything. So when we say transparency, it provides a clarity to physicians, so that promotes among the patients and leads to long-term improvements in outcomes. So as a provider, you have the obligation to inform patients about all appropriate treatment options, the risk and benefits of alternatives, and other information that may be pertinent, and including the existence of the payment models, financial incentives, formularies, guidelines, or other tools that influence treatment recommendation and care. Then scope of practice based on Republic Act. So we have here RA number 6111. So it is an act establishing the Philippine Medical Care Plan and creating the Philippine Medical Care Commission, prescribing its duties, powers, and functions, and appropriate funds thereof. So we have here Section 2, Declaration of Policy. There shall be a total coverage of medical services according to the needs of the patients. Here, if ever the patient is in need, so we should cater whatever necessary to the patient. So second, there shall be coordination and cooperation in the use of all medical facilities in both the government and private sector. For example, if a patient was rushed in a secondary level institution or hospital and they cannot cater what's need to be done to the patient, they need to coordinate to a higher level so that they can cater the treatment that needs to be done to the patient. Then third, the freedom of choice of physicians in hospitals and family, doctor-patient relationship shall be observed. So as a patient, they have the right to select who will be their physician. They have the right which hospital they want to be hospitalized, something like that. Then scope of practice for nurses. So here we have Republic Act number 9173, an act providing for more responsive nursing profession, repealing for the purpose of Republic Act number 7164, or other known as the Philippine Nursing Act of 1991, and for other purposes. So the broad scope of nursing practice reflects all of the roles and activities undertaken by registered nurses to address the full range of human experiences and responses to health and illnesses. So this includes the health promotion, health protection, health maintenance, health restoration, rehabilitation, and palliation. So to be responsive to the evolving health-related needs of the public, the boundaries of the scope of nursing practice must be flexible. Nursing practice takes place in the context of continuing change and development resulting from advances in research and technology, and the introduction of new approaches to care delivery and a greater variety of practitioners sharing more areas of common ability. So the dynamic nature of the healthcare environment requires that nurses respond to clients' needs by continually expanding their knowledge and skills and making judgments about the limits of their practice. So we have here section 28, scope of nursing. So a person shall be deemed to be practicing nursing within the meaning of this act when he or she, singly or in collaboration with other, initiates and performs nursing services to individuals, families, communities in any healthcare setting. So it shall be the duty of the nurse to first provide nursing care through the utilization of the nursing process. So here, as a nurse, we follow a process. We for example, in the documentation, we follow the ADPI. So we follow the assessment. So upon the assessing the patient, we will have a nursing diagnosis, and upon determining the nursing diagnosis, we will create a plan in order to resolve our diagnosis, the nursing diagnosis. Then of course, we're going to implement already the interventions based on the planning, and of course to evaluate already. So if the interventions provided are met or not met, then establish linkages with community resources and coordination with the healthcare team, provide health education to individuals, families, and communities. So this is very vital as a practice of a health of nurse, wherein health education and health teaching to the patient, to the families, or to the communities. Then teach, guide, and supervise students, and of course undertake nursing and health human resource development training and research, which shall include but not limited to the development of advanced nursing practice. Alright, so next is the scope of practices for pharmacists. We have here Republic Act number 10918. It is an act regulating and modernizing the practice of pharmacy in the Philippines, repealing for the purpose of RA number 5921, other known as the pharmacy law. So while pharmacists remain committed to assisting patients with access and information related to their prescription medications, pharmacists today are also providing a broad spectrum of services within their scope of practice, including conducting health and wellness testing, managing chronic diseases, and performing medication management. Also, administering immunization and work in and partnering with hospitals and health systems to adhere or to advance health and wellness, and helping to reduce hospital readmission. So under section 4, the scope of practice of pharmacy, when a person is deemed to be practicing pharmacy with the meaning of this act, when with or without a fee, salary, percentage, or other rewards paid or given directly or indirectly. So basically, for example, If you are working in a hospital, as a pharmacist, you should not receive any fee indirectly. It's like a tip, something like that. So it's against their scope of practice. Next is the scope of practices for medical technologies. We have here Republic Act number 5527, an act requiring the registration of medical technologies, defining their practice and for other purposes. So medical laboratory technologies all share a common scope of practice and are individually accountable for ensuring that they have the knowledge, skill, and judgment to practice safely. So the practice of medical laboratory technology is the performance of laboratory investigations on the human body or on specimens taken from the human body and the evaluation of technical sufficiency of the investigations and their results. So a person shall be deemed to be in the practice of medical technology within the meaning of this act who shall for a fee, salary, or other compensation or reward paid or given directly or indirectly through another renders any of the following professional services for the purpose of aiding the physician in the diagnosis, study, treatment of the diseases, and in the promotion of health in general. So here for week 7, we'll be tackling about the code of ethics for health care and also ethical and legal responsibilities. So the code of ethics clarifies the role and responsibilities within a profession and provides guidance to the professional for addressing common ethical questions. So the profession offers ethical principle to aid in the healthcare quality professionals execution of their duties as the member of the profession. So we have here the code of ethics for the nurses. So the primary ethical principles include first is beneficence. So when we say beneficence, it is an acting for good and welfare of others, including such attributes as kindness and charity. So an example of beneficence is a provider demonstrating this ethical principle is by holding a dying patient's hand. Another example is that resuscitating a drowning victim. Another example, providing pain medication as soon as possible to an injured patient in the emergency room. Or another example, lifting side rails on a patient's hospital bed to prevent falls. So that's beneficence. Next is non-maleficence. So when we say non-maleficence, it is an acting in such a way as to prevent harm to others or to inflict the minimal harm possible. So an example for this one is demonstrating this principle includes avoiding negligent care of a patient. So when we say negligence, you forgot to do something to that patient that wherein it harmed the patient. So that's for non-maleficence. So we should be avoid being negligent. Next is autonomy. So recognizing the individual's right to self-determination and decision making. So an example of autonomy is that a staff doctor plays a critical role in assessing and evaluating pain control measure for their patient. Another example is that the member of the interdisciplinary team needs the professional assessment information from the staff to identify the correct analgesic and most appropriate route, the dosage and interval to maximize the pain control. Next is justice. So acting in fairness. Um, acting in fairness to all individuals, treating other equally and showing all individuals at the same degree of respect and concern. So treating fairly. Next is veracity. So when we say veracity, being truthful, trustworthy, and accurate in all interactions with others. So sometimes providers feel that they have to tell a little white lie, bend the truth to spare a patient from unnecessary anxiety. Next is fidelity, so being loyal and faithful to individuals who place trust. Example is that a patient requests a provider not to reveal his terminal diagnosis to his family. So the patient explains that his family would probably disregard his wishes and keeps him alive no matter what the circumstances. Next is integrity, acting consistently with honesty and basing actions for moral standards. So being morally accountable and responsible for one's judgment and other actions is central to the provider's role as a moral agent. So, provider who practice with moral integrity possesses a strong sense of themselves and act in a way consistent with what they understand is the right thing to do. So, example is that keeping your promises even if it takes extra effort. um, Another example is that do not gossip or talking badly about someone. So next, the provisions focuses the following. So we have here the respect for human dignity. So human dignity is the recognition that human beings possess a special value intrinsic to their humanity, and as such are worthy of respect simply because they are human beings. Next is commitment to patient. So when you look up the definition of commitment, you'll see it concerns a pledge or a promise, an obligation to something. So I prefer the definition that describes commitment as dedication. So in healthcare, whatever area you are in, is not it is not a career upon which you can or should embark unless you are dedicated to it. Next is protection of the patient's rights. Of course, as a healthcare provider, we need to protect the rights of the patient, the right to medication, the right to information, right to choose their provider, and many more. Next is accountability. So, bears primary responsibility for the care of the patient. Next is professional growth. So when we say professional growth, strive always to promote health, safety, and well-being of self and of course the others. Then we have here the improvement of healthcare environment, advancement of the profession by attending such seminars and other webinars, then health promotion efforts and participation in goals of the profession. Then we have here the code of ethics for pharmacists. So pharmacists are health professionals who assist individuals in making the best use of medications. So this code, prepared and supported by pharmacists, is intended to state publicly the principles that form the fundamental basis of the roles and responsibilities of the pharmacist. And these principles based on moral obligations and virtues are established to guide pharmacists in relationship with patients, health professionals, and society. So pharmacists are health professionals who assist in individuals in making the best use of medications. So this code, prepared and supported by pharmacists, is intended to state publicly the principles that form the fundamental basis of the roles and responsibilities of pharmacists. So these principles based on moral obligations, as what I've mentioned, which are established to guide the pharmacist in a relationship with the patient. So for example, if a patient comes to you and asks for a certain drug, so it's the job of the pharmacist to tell what's the drug interaction or what's the is the drug action, so that the patient knows what's the drug all about. Next is continuation for the code of ethics for pharmacists. So pharmacist respects for conventional relationship between the patient and pharmacist. Pharmacist promotes good of every patient in caring, compassionate, and confidential manner. Then pharmacist respects the autonomy and dignity of each patient. So next is pharmacists act with honesty and integrity in professional relationship. Pharmacist maintains professional competence, so they are also competent. Same goes with other health providers. Pharmacists respect the values and abilities of colleagues and other health professionals. Pharmacist serves individual, community, and social needs. And of course, pharmacists seeks justice in the distribution of health resources. So, Code of Ethics for Medical Laboratory Technologies. The Code of Ethics describes the expected ethical obligations and principles that patients, the profession, and the public believe will guide the professional and personal conduct of all MLTs. So, the medical laboratory technologists shall strive for excellence in their professional practice and in their professional and personal conduct to uphold the integrity of the profession and the public trust. So they communicate effectively with patient, the public, the colleagues, and other health providers, contributing to a healthy and positive work environment. They also maintain and enhance professional practice and augment their knowledge, skills, judgment, and behavior through self-reflection and self-directed professional development, and by demonstrating continued competence. So we have here, as a medical technologist, so they have obligations to the patient, public, profession, regulatory body, or to oneself. So as a medical laboratory professional, they pledge to uphold their duties to this following the patient, the public, profession, regulatory body, and to themselves by placing patients' welfare above their own needs and desires. They also ensure that each patient receives care that is safe, effective, efficient, timely, equitable, and patient-centered. They maintain the dignity and respect for their profession. They promote advancement of their profession, ensuring collegial relationship within the clinical laboratory and with other patient care providers. And also they improve access to services. They also promotes equitable distribution of the resources and complying all the laws and regulations and protecting patients from other incompetent or illegal practice, and also changing conditions where necessary to advance the best interest of the patient. So we have here now the ethical and legal responsibilities. So medical law plays an important role in medical facility procedures and the way they care for the patient. So it is important for medical professional to understand medical law and ethics. So there are two reasons for medical professional to study law and ethics. First is to help them function at the highest professional level by providing competent, compassionate healthcare to patients, and of course to help to avoid legal problems that can threaten your ability to earn living. So it's very important as a health provider to know about medical law and ethics in order for you to be guided and provide any legal problems, and patients or significant others might not sue you if you follow the medical law and ethics. So we have here intentional torts. So when one person is intentionally harms another, so from the root word intention there, so the law allows the injured party to seek a remedy in a civil suit. So the injured party can be financially compensated for any harm done by the person guilty of committing the tort. So if the conduct is judged to be malicious, punitive damages may also be awarded. So here are some of the examples under intentional torts. We have here the assault. So when we say assault is open threat of bodily harm to another or acting in which as ways as to put another in the reasonable apprehension of bodily harm. So to cut it short, when we say a law, if you're going to threaten verbally a certain person, then when we say battery, there's already an action that causes bodily harm to another. So there's already a physical contact that harms the patient. So that's what meant by battery. Then defamation of character, so the damaging a person's reputation by making public statements that are both false and malicious is considered defamation of character. So defamation of character can take the form of slander or libel. So when we say slander, it is speaking damaging words intended to negatively influence others against an individual in a manner that jeopardize his or her reputation. Then when we say libel, it is a published false statement that is damaging to a person's reputation. So let me give you an example for assault. You're telling to a patient that you will inject them if they are too noisy or they are too lazy. That's an assault. For battery, if you're going to hold the patient's arm wherein the arm of the patient's already broke, wherein they are already injured. So that's there's already a physical contact. Then for defamation of character, you are saying such negative words to a certain patient or client. Then we have here false imprisonment. So false imprisonment is the intentional or unlawful restraint. So remember this, restraint or confinement of one person by another. So preventing a patient, example here is preventing a patient from leaving the facility might be seen as false imprisonment. So basically, false imprisonment, you don't want a certain patient leave um, the institution or the hospital, so that you can be charged false imprisonment. Then fraud consists if deceitful. So bear this in mind. So when we say fraud, deceitful practices in depriving or attempting to deprive another of his or her rights. So health care practitioners might be accused of fraud for promising patients miracle cures or for accepting fees from patients while using mystical or any spiritual powers or heal. So like the quack doctors or the albolarios, they are fraud because most especially if those quack doctors will accept fees, they can be charged fraud. Then invasion of privacy. So invasion of privacy is the interference with a person's right to be left alone. So entering a room, so here are some examples. Entering a room without knocking can be considered an invasion of privacy. So as a health provider, before you enter a room, you need to knock first. Then improper use of breach of confidentiality of medical records may be seen as invasion of privacy. So what does this mean? Improper use of breach of confidentiality. For example, you are not in charge in taking care of that certain patient, and then you took the chart and read the chart of that patient. You will be sued for invasion of privacy. So basically, healthcare providers who are taking care of that patients are the only ones should know or have the access to the records of the patient. Then we have here the unintentional tort. So the most common torts within the healthcare delivery systems were committed unintentionally. So unintentional torts are acts that are not intended to cause harm but are committed unreasonably or with disregard for the consequences. So basically these are accidental but it causes harm already to the patient. So we have here contracts. So when we say contract, it is an voluntary agreement between two parties in which specific promises are made for consideration. So the elements of contract are important to healthcare practitioners because healthcare delivery takes place under various types of contracts, and to be legally binding. So we have here four elements must be present in the contract. First is agreement. So one party makes an offer and another party accepts it. Of course, if the other way around, if the party does not accept it, of course, there's no agreement, there's no contract. So certain conditions to pertain to the offer we have here. It can relate to the present or to the future. It must be communicated. It must be in good faith and not under duress or as a joke. It must be clear enough to be understood by both parties. It must define what both parties will do if offer is accepted. For example, surgery. So both parties should accept it. But if one party does not accept it, there will be no surgery will happen. Next is consideration. So something of value is bargained for as part of the agreement. So the physician consideration is providing the service. The patient's consideration is payment for of the physician's fee. So of course, here in providing services, of course, there's always a payment. Then legal subject matter. Contracts are not valid and enforceable in court unless they are for legal services or purposes. So it is breach of contract may be charged if either party fails to comply with the terms of legally valid contract. So when we say legal subject matter, so for example, if you are the patient, you should be in the legal age. So if you are a minor, you cannot sign such contracts. It should be above 21 years old in order to sign such contracts. And if not, if the minor will sign the contract, it will be breach of contract. Right. So next is contractual capacity. Parties who enter into the agreement must be capable of fully understanding all its terms and conditions. Of course, if there is a contract, the conditions must be understood by the patients. For example, the patient has mental condition, so they are not capable of signing such contracts because they are not in good shape in mental condition, and they cannot really understand the terms and condition of the contract. Or another example is that if the patient is under the influence of alcohol, it would be against the contract. Then we have here the types of contracts. So we have here the express and implied. So when we say expressed, clearly stated in a written or spoken words. So a payment contract is an example of expressed contract. For implied contracts, so these are in which the acceptance or conduct of the parties rather than expressed words to create the contract. An example here is the patient roll-ups a sleeve and offers an arm for injection is creating an implied contract already. So without saying anything, if the patient will roll up his or her sleeve, that is already a sign that he or she accepts. Then we have here malpractice and negligence. So when we say malpractice, lawsuit by a patient against a physician for errors in diagnosis or treatment, while negligence cases are those in which a person believes that the medical profession did not perform an essential action or perform an improper one, thus harming the patient. So we have here some of the examples. So post-op or post-operative complication. So a patient starts to show signs of internal bleeding in the recovery room, wherein the surgeon must be sure that all veins should be closed or catheterized in order the patient will not bleed. And for that matter, if ever there's a bleeding, so of course there will be a reopening of the incision site, and it is discovered that the surgeon did not complete the closure of all the severed capillaries at the operation site. Then we have here the res ipsa loquitur, which means the thing speaks for itself, refers to a case in which the doctor's fault is completely obvious. So if ever without really looking into it and through the procedure, it already shows the error of the patient, the doctor or any health provider might suit res ipsa loquitur. Then we have here also examples of negligence. We have here abandonment. So abandonment is wherein a health professional stops caring without providing an equal qualified substitute, is considered to be abandonment. Then we have here delayed treatment. So a patient shows symptoms of some illness or disorder, but the doctor decides for whatever reason delays the treatment. So if the patient later learn of the doctor's decision to wait, the patient may believe he has neglected the case. Or another example, if you are the nurse, Then supposedly you will be providing a medication to the patient at 8 o'clock, but then you fail to provide the medication at 8 o'clock and you experience some symptoms. So the nurse might be charged delayed treatment or negligence for delaying the treatment. Then we have here negligence cases sometimes classified using the following three legal terms. We have malfeasance, misfeasance, nonfeasance. So when we say malfeasance, derived from the French word malfaisance, which means wrongdoing. So what are some of the examples of malfeasance? One is that one example is that, for example, anesthesiologist administers an incorrect dosage to the patient who is undergoing surgery, and the patient suffers significant liver damage. So there's already a wrongdoing of the anesthesiologist. Another example, the resident surgeon accidentally puncturing another organ, causing further infection of the patient. So with that, there's already a wrongdoing of the surgeon, wherein it caused more damage to the patient. So that's what meant for malfeasance. Then misfeasance is derived from the French word misfeasance, meaning misdo. So remember these key terms or keywords for you to be guided. So misdo, example of misfeasance. Ryan is diagnosed with generalized seizure. So then the nurse forgot to inform the significant other or the family members to never leave the patient unattended. Then Ryan had a seizure episodes causing to fall out of the bed. So from there's already a negligence under misfeasance wherein the nurse missed in telling the significant other, the family of Ryan, not to leave the patient because of the condition of the patient. Then lastly, we have non-feasance, is derived from the French word faisance, meaning action, and the prefix non, which means not. So therefore, not action or non-action. So non-feasance would apply when example here, apply when a physician does not order necessary tests. Another example, if a daycare provider is employed to supervise children and he or she fails to prevent a child from climbing out on the window ledge from which the child falls. So there's already non-action of the daycare provider. Another example, a doctor has a legal obligation to provide medical care to patients. So if an accident, a victim is wheeled to the hospital, the medical personnel at the hospital are required to provide medical attention to the patient immediately. So if the doctors failed to attend to the patient in time and the patient succumbs to their injuries, doctors are considered to have committed non-feasance because there's non-action of the providers, especially that is an emergency situation. So we have here 4 Ds of the negligence. We have, remember these key words or mnemonics, that the do, the damages, derelict, direct cause, and duty. So for damages, for you to be charged negligence, there should be a damage. So patient must prove that they suffered injury. Then for derelict, patient must show that the physician or health provider failed to comply with the standards of the profession. Then direct cause. So patient must show that any damages were a direct cause of the provider's breach of duty. And lastly, duty. The patient must show that there is a provider-patient relationship existed in which the provider owned the patient duty. Of course, you will not be charged negligence if you are not handling that patient or client. Then settling malpractice suit, we have here arbitration. So when we say arbitration is a process in which the opposing sides choose a person or persons outside the court system. Take note, outside the court system, often with special knowledge in the field to hear and decide the dispute. So if injury or failure to provide reasonable care or abandonment of the patient is proved to have occurred, the provider must pay any damages or, example, the financial award to the injured party. Then we have here subpoena. in settling malpractice. So when we say subpoena, it is a written court order addressed to specific persons requiring that person's presence in court on specific date at a specific time. So if you were directly involved in the patient's case that precipitated the lawsuit, you might be subpoenaed. Then we have subpoena duce tecum, which is a court order to produce documents. So if you are in charge of a patient's record at the practice, you may be required to locate, assemble, photocopy, or arrange for delivery of patient's record for these purposes. So those are some ways in settling malpractice lawsuits.